Good afternoon, everybody. My name is Donna Feazell, and I'm your host of The Edge on IC Radio, your source for news and entertainment. You can also find us on television, channel 182 on Charter Communications, and we're syndicated on Abundant Television, found on Roku, Apple TV, and Amazon Fire. Everything is up in the air right now in this world about the indictment of President Donald Trump, and so I've been asked a few questions, and these are some questions I've had as well. So this is from a website, and these are attorneys, Burnham and Gorgahov, PLLC.com. So you can go ahead and find the answers here. Okay, what is a federal indictment? Let's go ahead and dive in right now. So what is a federal indictment? An indictment is a formal accusation against one or more defendants, charging them with one or more crimes. In the federal criminal system, the indictment is the principal method by which a prosecutor initiates criminal proceedings. For certain types of crimes and under certain conditions, the prosecutor may, instead of an indictment, rely on a criminal information or a criminal complaint to formally begin the case. Later in this article, we're going to briefly explain the differences between each one of these legal documents, which are also called pleadings. And I hope this makes a lot of sense to you. When I was reading through this, it's all confusing. It seems to us as if the laws are changed, depending on who is being indicted. But we're going to go through this, and let's see if we can figure this out. Okay, an example of a federal indictment. Although the appearance of an indictment may vary from one jurisdiction to the other, there are some commonalities to the structure and content. And we wish to remind you that if you've been charged with a crime, you should consult an attorney, okay, to understand the charges in your individual case instead of relying solely on information you find anywhere on the internet, okay, because first of all, in each state, they have different laws. There's a commonality, but then there are some differences, okay, depending on the state you're in. Okay, you should consult the attorney. With that said, let's use an example of an indictment filed in the United States District Court for the Eastern District of Virginia. It's the Alexandria Division, to illustrate the parts of a federal indictment. Okay, now this is the first bullet point. At the top of the document is the name of the district court where the case is pending. In the example, the court is in the Alexandria Division of the United States District Court for the Eastern District of Virginia. And then also below that is the court name, which we call the caption of the case. We're just kind of trying to understand. That way, if you're looking on the internet, don't rely on garbage you hear on the internet as far as, how this thing is actually coming to fruition here for President Trump. Then I'm just giving you so that you can have a better understanding what the indictment looks like, okay? All right, so we saw the court name, and then also the caption identifies the parties to the action, the case number, and the counts or the charges that are contained in the indictment. Now, for the example, you also see this is a case by the United States of America against Keith Johnson and Angela Johnson, which are the two defendants. Sometimes a criminal case may be brought when the name or names of some of the defendant or defendants are still unknown, such as a large criminal conspiracies where not every member of the conspiracy has been identified at the time of the indictment. Now, in such cases, the prosecution may use placeholder names such as Jane Doe or John Doe for some of the defendants. In addition, the defendant can also be a legal entity such as a corporation. Thus, an indictment can charge a company such as, say, Acme Corporation. If a defendant has nicknames or aliases, the indictment will frequently include those nicknames or aliases next to the defendant's legal name. For example, an indictment may identify a defendant as John Smith, also known as Johnny, also known as John. There's no legal requirement for the prosecution to use the defendant's known aliases. Prosecutors, however, like to include this information to create an appearance of criminality, particularly where aliases sound sinister or thuggish. So you may see different names, and it's to make it sound as if it's thuggy, just like this says. Okay, to the right of the parties' names, there's usually a case number. In the example, the case number is 131 semicolon 13, then CR 305, which tells us this indictment was filed on 2013. That's the 113. And it was a criminal case, CR, and was the 305th criminal case filed in the year in the Alexandria Federal Court. In case you're wondering what all those little numbers and stuff stand for. Now, also below the case number, you'll see that this indictment contains 9 courts. Sometimes this is called charges. 9 counts, I'm sorry. Sometimes this is called charges. Each count corresponds to an alleged violation of a particular law. Now, the count is an important unit in federal criminal cases. There's a trial. If there's a trial, the jury will have to vote guilty or not guilty on each count. If there is a conviction, the judge imposes a sentence for each count of conviction, and the nature and the number of the counts influence the total sentence imposed. Now, in our example, there's 1 count of conspiracy to commit wire fraud and 8 more counts on wire fraud. Now, after the caption, there is a narrative. Now, the narrative is usually organized in numbered paragraphs and is designed to describe more specifically the crimes that the defendants are alleged to have committed. Now, remember, remember the word alleged, okay? Alleged. A lot of people in the media world use the word alleged to make it sound as if it's something that definitely has happened. Alleged doesn't mean that this particular thing has happened, okay? So let's remember that. Okay, there may be an introductory narrative that gives background information such as the biological details or biographical details for the defendants and other individuals involved in the case. Now, not all indictment will look like this particular example. Also depends on the state. Sometimes an indictment may be very short and contain only a paragraph for each count. The paragraphs may simply repeat the language used by the statutes that the defendants are charged with violating. In such cases, a defense attorney may need to file a motion for what is called a bill of particulars to obtain more information. Again, if you've been charged with a crime and you're trying to understand the indictment, you should, in addition to reading and listening to what I'm saying right here on the show, you need to consult an attorney. Okay, how do prosecutors obtain federal indictments? How's that done? By law, a federal indictment can only be brought, or in technical terms, returned by a grand jury, which is a body of 16 to 23 citizens chosen from the community. The grand jury hears evidence and testimony from witnesses presented by the prosecution. It has the power to ask questions and subpoena witnesses and documents on its own. Once the grand jury hears the evidence, it votes to indict or not to indict. This is based on whether there is probable cause to believe the defendant is guilty. Now, a minimum of 16 grand jurors must be present to vote, and at least 12 must vote in favor of an indictment before charges can be brought. If the grand jury votes to indict, it will return a true bill signed by the foreperson of the grand jury. That's why in all federal indictments, there is a stamped or typed statement at the end of each document with the words, "a true bill," and that's in quotes, "a true bill." You may have heard the expression that prosecutors can indict a ham sandwich. Who knows anymore? This reflects the facts that, number one, grand jury proceedings are secret and closed to the public. The defense has no opportunity to present evidence at a grand jury proceeding, challenge the prosecutor's evidence, or present its side of the story. Now, the probable cause, and we got that in quotes, probable cause, remember that, statement is one of the lowest standards in criminal law, defined as requiring only sufficient evidence to lead a reasonable person to believe that a crime has been committed and that the defendant is guilty. This stands in stark contrast to beyond a reasonable doubt, which is necessary to convict a defendant at trial. Okay, now, This is another question. Can the indictment be amended or changed to charge different or new crimes? That's been my question. Okay, so here we go. Technically speaking, an indictment cannot be amended once it has been returned by the grand jury, because that would violate the defendant's Fifth Amendment right to be indicted by a grand jury. However, it's also true that prosecutors do frequently alter the crimes charged or even add new charges during the course of a criminal proceeding. Prosecutors accomplish this by filing what is called a superseding indictment. A superseding indictment is just like any other indictment. It must be obtained the same way as the original indictment, through a grand jury. The superseding indictment can include different charges, new charges, or add new defendants. Now, once the grand jury returns a superseding indictment, the superseding indictment replaces or supersedes the original indictment. It can get really interesting the next few weeks with President Trump. What information must a federal indictment contain? Okay, the Sixth Amendment guarantees the accused the right to be informed of the nature and cause of the accusation. Therefore, the indictment must have enough information to inform the defendant both the nature and the cause of the crime charged. The federal rules of criminal procedure are another source of law governing indictments. According to the rules, the indictment must be plain, concise, and definite written statement of the essential facts constituting the offense charged. Furthermore, the indictment must allege facts that, if true, constitute a federal crime. For example, if an indictment alleged that John stole merchandise from the department store, and if stealing from a department store is only a state but not federal crime, then the indictment in the case would be invalid because it did not allege a federal crime. Finally, the case law developed from court decisions also shape what must be in an indictment. Now, the most significant law in this category came from a series of cases, beginning with the Supreme Court's decision in Apprendi versus New Jersey. Now, this is 530 U.S. 466, 2000. Under Apprendi and its progeny, any factor other than a prior conviction which has the effect of increasing a statutory maximum sentence or setting a mandatory minimum sentence must be pleaded in the indictment. Okay, let's go ahead and cut to a commercial break. We're running real close to it because we have several things we're going to discuss, and we'll be right back in just a few minutes, so you hang in there, okay? Very interesting subject.
At Lamone's Mexican Restaurant, located in Henniger, Alabama, and voted Best Mexican Restaurant of DeKalb County, Alabama 2020, we're here to serve you with authentic Mexican cuisine. Order easily online by going to lamonsmex.com or call 256-657-3999 to place your order. We're open Sunday through Thursday, 11 a.m. to 9 p.m. and Friday and Saturday, 11 a.m. to 10 p.m. Whether you're celebrating a cozy date night for two or a celebration for a crowd, at Lamone's you'll love our atmosphere and friendly servers. Thank you for dining with Lamone's Mexican Restaurant. Let Rhonda at Rhonda's Elite Tax LLC take the burden off you for all your tax needs. I know because Rhonda has been taking care of my business since 2013. I feel Rhonda works for me because she knows the direct questions to ask to better benefit my unique business in order for me to get back the biggest refund possible. Rhonda is an ongoing student, and she knows tax laws are in a constant change every year. Call 256-281-9903 for an appointment to take the dread out of getting your taxes done. Rhonda is located at 11968 U.S. Highway 431 in Boaz. Again, that number is 256-281-9903. And let Rhonda's Elite Tax LLC champion your personal and business taxes.
you ready?
We all wonder what tomorrow will bring, but the future lays itself at the feet of the prepared and surrenders to the will of the persistent. It's not easy, but today shapes you so you can shape tomorrow. With Northeast Alabama Community College, when the future asks if you're ready, you can answer.
Yes.
Begin your future at Northeast Alabama Community
Good
College.
afternoon. My name is Donna Fiesel, and I'm your host of The Edge on IC Radio, your source for news and entertainment. You can also find us on television, channel 182 on Charter Communications, and we are syndicated worldwide on Abundance Television, which is found on Roku, Apple TV, and Amazon Fire. Thank you so much for watching. We are talking about the buzz all over the place is President Trump being indicted. A lot of things are going to be happening the next week or so. And it could be a slam dunk, something done in just a few days, but I don't know about that at all because there are two sides. Basically, what's going on is it's the side of the Democrats versus the Republicans. That's the only way I know how to say this. Okay, so in order, they're trying to keep Trump from running, and I really feel this is just it's a cascade of a circus, is all I can say. Okay, what is a speaking indictment? What do I need to be aware of? Okay, a speaking indictment is a term used by criminal law practitioners to refer to a lengthy and detailed indictment that includes more facts and allegations than is required by law. Now, prosecutors have discretion in selecting how much information to include in an indictment. Sometimes defense attorneys can have and make a motion to strike where the speaking indictment contains unnecessary allegations. Now, speaking indictments can have both negative and positive implications for the defense. On the one hand, they can provide defense attorneys with a roadmap of the way the prosecution views the case and is thus beneficial for that perspective. On the other hand, judges sometimes allow the jury to make copies of the indictment, and a speaking indictment may be prejudice the jury because it is a written copy of the prosecutor's version of the case. A skilled federal defense lawyer who has experience with speaking indictments will develop a strategy that is most advantageous to the client when faced with such an indictment. Now, another question. What is the difference between a federal indictment, a criminal complaint, and a criminal information? Okay, as mentioned earlier, an indictment is only one way for federal prosecutors to bring criminal charges. Other ways for prosecutors to bring criminal charges include using the criminal information and the criminal complaint. A criminal information is similar to an indictment that it serves as a document formally accusing the defendant of committing one or more crimes. The main difference between the two is that a criminal information does not require a grand jury proceeding. This allows federal prosecutors to conserve resources. So in federal misdemeanor cases, there is no Fifth Amendment right to indictment by grand jury, and prosecutors therefore prefer to use criminal information instead of an indictment. To federal felony cases, the criminal may choose to waive or give up his Fifth Amendment right to indictment by a grand jury and be charged by criminal information instead. Now, this happens most frequently where the defendant and the prosecutor have reached an agreement as to a guilty plea to a particular offense before an indictment was returned, or where the final plea is to an offense different than that originally charged in an indictment. A criminal complaint, by contrast, is frequently used when prosecutors need to make an arrest quickly. This may happen, for example, when federal agents learn that a crime is about to occur or has just occurred and must act immediately. Now, in this situation, prosecutors do not have the time to go through the grand jury process. Instead, prosecutors file a written document called a criminal complaint, together with an affidavit signed by an agent familiar with the case. A judge or a magistrate judge will review the complaint and the affidavit and issue an arrest warrant if he or she finds probable cause. Once an arrest is made on a criminal complaint, federal law requires that the defendant must be charged by an indictment or by a criminal information if it's a misdemeanor case, or if the defendant agrees to waive indictment, and this is within 30 days. How can a federal indictment be used in court? Okay, an indictment legally is not evidence. Okay, so something happened a few years ago. I was working for a radio station. I had to leave because I developed asthma, and the station owner smoked in the studio, so that's how I got it. And there were 6 different kinds of mold found there. He was afraid I was going to sue him, and basically I just wanted to move on because the guy was not capable. It would have just been a complete waste of my time, and I just wanted to move ahead and just not think about it. So he gets in touch with a relative of mine. She got in contact with him basically. So 2 heads got together, and they were actually telling people I was being indicted by this guy. Freaked me out because I've never been in trouble before. I've never been perfect, but I'm basically a boring person. And again now, I was going to let this whole thing slide. I didn't even want to talk about it to people. So what happened is I called our district attorney. He happened to be someone who'd been on my show quite frequently. He thought I was kidding around. And I called him and I said, I've been indicted. And he said, oh, come on, I'm busy. And then he said, I'll talk to you later, bye. And then I said, wait, no, I have been indicted. And he said, no, you haven't. He said, first of all, this bozo could not indict anybody. You know, no one, they can spread a rumor if they want to, but they can't indict anybody. I should have went on ahead and sued for defamation of character. But anyway, he said, no, first of all, nobody's going to believe him. He said, you know, he has a bad reputation. You got a good reputation. He said, nobody's going to believe it. So this whole thing, it can be a rumor that someone spreads, which is what happened to me. And by the way, nothing ever came of it. I was not indicted. Nothing like that happened. But he and this family member of mine tried to take me down, and that's how they did it. So that's why I want evidence first. I'm not going to run around saying that President Trump has done something. I'm just not going to do that because something not that bad, not that big of a case, but something was done similar to me. So anyway, I believe in keeping my mouth shut and listening, and I hope you do too. Okay, just listen and see how everything plays out. By the way, he who speaks first loses. That's the way it always is. And that's what the book of Proverbs says as well. He who speaks first loses. Doesn't say it quite that way, but that's what it is. How can a federal indictment be used in court? Now, an indictment legally is not evidence. This means that jurors are not permitted to rely on the indictment to conclude that a defendant is guilty. Nonetheless, it is common for any laypersons to be swayed by the allegations in an indictment. Some federal judges have a practice of allowing the jury to read the indictment during deliberations, on the theory that this will help the jury understand the charges. Now, the judge will still instruct the jury that the indictment is not evidence and may not be considered in arriving at a verdict. While most jurors are good at following instructions, there may be reasons for certain cases to object to the indictment being reviewed by the jury. On the other hand, in some cases, it will be advantageous to have the jury review the indictment. An experienced defense attorney should evaluate this question carefully in order to provide you with the best strategy and advice based on the facts of your case. Now, can a federal indictment be challenged? Yes. Listen to this. The most obvious and most common challenge to an indictment is showing the allegations are not true at a trial. But what about challenging an indictment before the trial? There are a number of different challenges that can be made to an indictment before a case gets to trial. Such challenges will be very fact-intensive based on the individual circumstances of each case. There are some examples right here that an indictment can be challenged. For failing to provide sufficient detail to a defendant, such as the basis and nature of the charges against him. Number 2 would be failing to set forth an actual violation of the law. Number 3, failing to plead all the elements of a crime. Number 4, alleging a crime outside the statute of limitations. Bringing a criminal case to an improper venue. The prosecutor's failure to accurately advise the grand jury on the applicable law during the grand jury phase of a case or other misconduct. Still got issues with working at this place I was telling you about. While a successful challenge to an indictment is a rare occurrence, a skilled federal criminal defense attorney will often assert challenges to the indictment for other reasons as well. For example, the prosecutors may be ordered to provide more evidence or to provide the evidence earlier than they otherwise would be required. Now here's the conclusion. Again, you'll find this on burnhamgorokhove.com. Let me spell it for you. BurnhamGorokhove.com. You can find this exact information right here. Here's the conclusion. A federal criminal indictment is a serious matter because it means that the criminal investigation has progressed to a point where the prosecutor now believes that he or she has enough evidence to convict. Moreover, for some clients, an indictment itself, even though it's only an accusation, can entail serious consequences such as the loss of employment, harm to reputation, and frozen assets. This is in addition to the anxiety and stress of being charged with a federal crime. When we represent clients early on in the criminal process, so says this attorney, during the investigation phase, the goal is to always avoid an indictment. However, where a client is indicted, it is important to respond intelligently and efficiently in order to put the client in the best position of achieving a successful outcome. Okay, now I'm going to rephrase. I'm going to mention this again, okay? Can't say this enough. If you have been indicted, you should speak to an attorney right away if you do not have one. And if you do have an attorney, you should discuss the indictment thoroughly with him or her to understand the allegations and consider what challenges can be made. Now, this whole thing right here is just, we're all learning a lot about law. Let me tell you what my opinion is about what's happening in this case here with President Donald J. Trump. First of all, what you're doing is you're opening the doors for all sides. I think this should be nonpartisan. I really do. Whether you are a Democrat or you are a Republican or you are an independent, all this is doing is opening up Pandora's box. You're going to see many more crazy things in this world happen because of this indictment. A whole lot of folks are not really thinking ahead. Do I think it's going to catapult Trump? Yeah, I do. Because the people I am speaking with right now are really at the point they're fed up with this whole thing and they are mad. And I really think it's going to catapult. He'll probably wind up being the next president because of all of this. I'm just saying. But if you're a Democrat, Republican, or an independent, you should be very upset about this whole thing. Okay, it's going to change the way we do things because the next person indicted, it won't be a Republican, maybe a Democrat. You just never know. My name is Donna Feazell, and I'm your host of The Edge on IC Radio. We are your source for news and entertainment. You can also find us on television, channel 182 on Charter Communications, as well as Abundant TV. We're just found on Roku, Apple TV, and Amazon Fire. Again, thank you so much for watching. We definitely appreciate you. And if you can think of anything else you would like for me to discuss, this is one of them you would like for me to discuss, I'll be glad to do that. Just give me a couple of days heads up so I can go ahead and do some research. Again, thank you for watching. By the way, my telephone number is 256-659-4319. If you'd prefer to send an email, my email address is donna@theedge. donna@theedge.com. I'll give you another one, donna@donnasedge.com. You take care.